Welcome to this new episode of the Panel Fit monthly chat that actually it's going fortnightly in this period, because today we start with the promotion of our deliverables, the first deliverables of the project, that speaking outside of the European project jargon means reports and analysis on different aspects of the topics we focus on, which are mainly data protection and privacy in the field of research and ICT. And today we will focus on the issues and gaps analysis, on informed consent in the context of ICT research and innovation. I have put the link to the deliverables in the chat, in the text chat. So if you want to take a look and download these and other deliverables, you're free to do so. And our guest today is Alessandro Ortalda, who is first of all, welcome, Alessandro.
Thank you, Federico, and thank you for the audience for the participation.
And I briefly introduce you. Alessandro is a doctoral researcher at the Law, Science, Technology, and Society Research Groups at Vrije Universiteit in Brussels, and joined the Panel Fit project in September. Before working in the academia, Alessandro used to work as a cybersecurity and data protection consultant. He worked for organizations in the areas of energy, oil and gas, ICT, and with governmental agencies, supporting their data protection officers and helping privacy officers to implement the provisions of the GDPR. So, as always, we will have a conversation with our guest, and in the last part of this chat we will leave some time for questions. So if you have some, you can, as you prefer, type them in the text chat or raise your hand, and you will directly ask your questions to Alessandro. So let's start right away. Can you briefly summarize the main goal of this document, this analysis, and its relevance in the progress of data protection regulation in Europe?
Certainly. Well, the critical analysis is one of the deliverables that the Panel Fit Consortium has been tasked to develop. Its primary goals are two, essentially. First of all, to identify potential issues or gaps in the legal framework for data protection in the context of research, so very well-defined perimeter for the Panel Fit Consortium. And secondly, to come up with suggestions for the regulators on how to mitigate these issues and how to close these gaps. Now, if we have to talk about relevance, I really believe the document could not have come at a more appropriate moment. We are all well aware of the scenario that Europe and the rest of the world is facing due to the COVID-19 health emergency. In the past months, all of us witnessed not only the incredible effort that the health institutions put in managing the crisis, but we also saw a wide engagement of the research community in searching for potential solutions. And here it must be stressed out that it is not only the medical research community that has been involved, but the ICT research community as well. Indeed, we all know, I mean, I believe it's clear to everybody that ICT is a powerful instrument, is crucial actually in helping to fight the pandemic, from contact tracing to simply keeping citizens informed. And in this scenario, the use of data has been massive, and it's likely expected to grow. And if you also consider the urgency of the situation, you might you might see that this could have put ICT research communities under a lot of stress, introducing the risk for them maybe to overlook certain aspect of data protection when carrying out their research, especially if you consider that research activities in the legal framework enjoy a specific legal regime. Okay, so you need even more specialized knowledge to deal with them accordingly. Knowledge that researchers outside of the legal space might not necessarily have. So in this context, the critical analysis that we produced serves, I would say, at least two purposes. Not only casting light on certain issues and certain gaps that we identified and likely need to be addressed in the next future, but also helps to normalize, if I may say, the knowledge base um, uh, around this area of data protection in research, and might help researchers to understand certain fundamental topics of data protection in regard to this specific kind of activities.
Yeah, that's very clear, and I agree that this specific topic is very relevant right now. Yeah, right, maybe more than before. And what was the approach when compiling this analysis? Did you aim to mention all the relevant issues, or just identifying the most important according to some criteria? And if so, which were the criteria?
So the group of work tried to have an approach that was structured as much as possible. So first of all, we actually identified some of the most important researchers and experts that have already dealt with this topic of data protection and scientific research. Then we organized a workshop where we invited these experts. We brought them to the table to discuss and share opinions about this particular subject. Now, if memory does not fail me, more than 15 institutions participated to the 2-day workshop. So quite a comprehensive participation. Institution where universities, research centers, think tanks, and kinds like that. By the way, if I just touch upon on this point very briefly, the discussion that we held during the workshop has actually been published in a special issue of a Computer Law and Security Review, and I strongly suggest anyone interested in the topic to go and have a look at this issue, because it is very enlightening on the topics that have been discussed. So, but going back to your question, going back to the analysis, we tried to have an approach. We tried to come up with results that were not the outcome of purely theoretical work of some academic researcher. So I would say that probably the one of the main criteria that we adopted in terms of identifying and listing the issues was real life experience. And these both during the discussion that we held in the workshop, but also in the creation of the subsequent contents that we put in the critical analysis. Both these aspects have been actually informed by discussions and interviews with peers and members scientific community. And this was actually made possible by the fact that the members of the panel fit consortium are universities, research institutions, or at least entities that have a direct relation to research institution or direct access to research facilities and teams. So meaning that the consortium was actually well positioned to get primary account of the main challenges that the research community have to face on a daily basis. Then the results of this let's call it informal assessment, we have a look at that and we try to understand where these issues were actually connected with gaps or problems in the legal framework, so existing problems, and where they were not. Maybe simply because the researchers we involved had no real understanding of the legal framework. I mean, this could be the case if you talk with researchers that do not have a legal background. So it might happen that their issues are simply the results of not knowing exactly all the nuances of the legal framework. So from this point, we then identified the issues that we put in the critical analysis. And if I remember correctly, you asked me if we put in the critical analysis all the issues that we identified. Well, the answer is yes. All the issues that
Sorry, I can't hear you anymore.
Sorry, someone from the audience actually muted me.
Oh,
maybe I was talking too much.
I hijacked. Okay.
No, but
Okay.
so just to conclude, yes, we put all of the issues that we identified as real issues in the document, and actually the main topic is consent, as correctly in the title of the event today. But we actually took the chance to touch upon other issues in the legal framework that might nonetheless be very relevant to the research field. So out of the 15 or so issues, I don't remember exactly the number, but the majority are about consent, but there are also other issues that we investigated.
Yeah, and going forward from the process to the actual result of your work, the next question is quite straightforward. So, which are the main challenges that you found in the field of consent, and I would say both on the side of the data subject and of researchers. And as you said, it's not just consent. There are also other legal bases that you analyzed. So, yeah, feel free to mention a bit the main key points of the research.
Okay, well, I'm not so sure we can identify like main issues that stands above other, and we certainly do not have time to go through all of them. But maybe I can bring a couple of examples. Yeah, for instance, one of the questions that we looked at, one of the issues that we looked at, is that the question was, how can we exactly and with precision measure if the consent that is provided by data subject is given freely. We know this is one of the requirement of the GDPR, and in itself this is already a problematic aspect. It's not easy to be addressed, but in the context of research, there may be some aspects that make this problem even more relevant. If you think about it, it is not uncommon for research institutions to be perceived as authoritative bodies, or maybe emanation of the official authority. Think, for instance, to a hospital. Okay, hospitals are often research institutions as well, and it is not uncommon for a citizen. So in our case, for a data subject,
Sorry, I've lost you once more. So once again.
Can you hear me now?
Yes.
Yeah, there is someone keeping.
Can you please stop muting Alessandro, whoever you are, please?
I'm not naming and shaming. I can see the name, but I'm.
No, okay. Let's keep it secret. Sorry, you were talking about the fact that hospitals are perceived as public institutions, and
they might be perceived as in this light by data subject, and in a scenario like this one, you actually have an imbalance between the data subject and the research institution. So you might question if the consent that data subjects provide to this kind of institution is really free. Now, we know that the GDPR recognizes this risk of imbalance. So in a sense, it's kind of a known issue. Okay, it is explicitly mentioned in the GDPR. However, there are currently no clear guidelines for research institution on how to mitigate such a risk. And since we just stressed out how this is very relevant for research institution, we believe that this is an area where an authoritative bodies can intervene and fill the gap with guidelines or some sort of opinion. Now, if another issue, which is actually another kind of imbalance, is that public authority actually cannot rely on legitimate interest when processing data. Okay, this together with the fact that a clear-cut, unequivocal definition of public authority is not provided for in the legal framework, this might create an imbalance with private research institution. Okay, in the example before, we said that hospitals, for instance, they might be associated with the public authority. So in a sense, according to certain interpretation, they might fall in this category, and they might not have access to legitimate interest as a legal basis for processing data. Now, the consequences of these other kind of imbalances are not fully understood yet, and certainly more analysis in this area is necessary. But what we understood, what we found, is that the situation may actually potentially give public research institutions, such as hospitals or universities, a competitive disadvantage when they are faced with research with private institutions as well.
Okay. Yeah, it's a very interesting and very compelling point of view on the, and I can tell the audience that there are many other relevant issues tackled by the analysis, and I really encourage you to download the report, because if you are into these topics, it's very, very interesting. And
Federico, apologies if I may, just to
yes.
Add to this last point. We would actually be happy to have a discussion with the audience about the other subjects. So our contacts are easily available in the website of VUB. So if you happen to read the document and have feedbacks or ideas or things that you want to discuss, you can reach out to us and we can have a conversation about this. We actually would love to do it.
Yes, and like occasion like today's chat are one of these occasion actually. So we'll see later if someone wants to ask questions, and I will share also the contacts of your department in our website and our Twitter profile. So yeah, going on, you maybe a bit on the approach side of this analysis. I noticed that you frequently rely on guidelines and opinions by authoritative bodies as a way to address the different issues for mitigations or solutions. So it seems the message is like, we don't need more rules, we just need to improve what we have, or to clarify maybe what we have. So is this a correct interpretation?
Well, our job, strictly speaking, was not to express an opinion on the need to update the framework with new law, but rather it was simply to first pinpoint certain issues that we considered to be problematic and to propose approaches to solve them. Now, that being said, yes, it is true. We relied quite a lot on guidelines and opinions, not because we believed a priori that the law is already fit for the purpose. We haven't approached the issues saying, well, okay, the law is already fine. Let's find a way to make it work. But we actually looked at each of the issues very agnostically and evaluated on for each one of them what, in our opinion, could be the best course of action to close a gap or solve the issues. And the fact that we so often relied on guidelines and opinions derives mostly from there are two reasons for that. The first one is that we haven't identified in the legal framework issues that prove to be so critical as to require an amendment of the law per se. We have not found blocking issues, unapplicable provisions, or maybe internal contradictions. And the second reason is that in most of the cases, in all of the cases actually, for the issues that we identified, we believed that opinion and guidelines are the best possible solutions, and this is because these instruments are not only are expressly mentioned by the GDPR, for instance, in Article, my memory is so bad, Article 70, if I remember correctly, in regard to the duties and tasks of the EDPB, but also because these instruments are already largely adopted. Nowadays is quite common actually to rely on guidelines and opinions by, for instance, the Working Party 29 or the EDPS or maybe national data protection authorities. So these makes them already familiar to data controllers and data processors, and in our opinion makes them best suited for addressing certain issues rather than going through an unnecessary, complex, and often unnecessary process of amending the law.
Yeah, maybe sometimes my question maybe comes from the fact that I don't have a legal background, so the naive approach is, okay, there's a problem, we need another law. So yeah,
but sometimes it is a sensible approach. We just believe that this time this is not the case.
Yes. And yeah, last question, more about to try to go a bit beyond the scope of research. I like to ask you if you think that some of the considerations and suggestions that are mentioned in the report are applicable beyond the scope. For instance, I'm thinking about the question of cookie banners and the real-time bidding system for programmatic advertising. This has been questioned by different NGOs and organizations that try to protect digital rights and rights, privacy rights of the citizens. Do you think that this can have the two fields can have some relations?
Well, yes. Well, it's certainly true that that many of the issues presented by the critical analysis can be actually extended beyond outside the field of research. Or if you want to word it differently, we can say that many of the issues that we identified in the critical analysis, which are more general in nature, have specific impacts on research activities. So it depends how you want to look at that. So think for instance to the example that I provided before, the one about the imbalance between data subjects and research institutions. Now, if in that example you change the research institution with any other kind of entity that enjoys a certain degree of authority in the eyes of the data subjects, then you understand how this issue is not limited to the research activities. It's not limited to research institutions. Another issue, for instance, in the same fashion, think about the current requirements for transparent and clear information to the data subject. Okay, as of today, apart from certain guidance provided by the Working Party 29, there are no clear, unequivocal guidelines on how to interpret this requirement, and there are no guidelines that tells exactly data controllers how to implement an effective, transparent, and clear information to the subject. The GDPR actually envisages, for instance, the use of icon sets and other kinds of visual aids to facilitate this information sharing. If you think about these standardized basic designs, customizable standardized basic design provided by an authoritative body would actually great help data controllers in general, not only those active in research. And this was actually one of the issues that we identified in the document. So yes, many of the issues that we identified have relevance outside of research. But I think it's worth putting on the table a word of caution. The document was specifically tailored on the area of research. So the object of the document was primarily to look at the legal framework of data protection legal framework around research. This means that whenever in search for guidance, a good practice would be to first rely on something specific for the aspects you're looking into, and only then extend to our critical analysis if nothing else can be found. So even if what we provided in the document has a relevance outside research, I would approach the document with care, because that was not the primary goal of the analysis.
Yeah, thank you. I think it's very sensible that you make this last remark. But my question was like to highlight also the fact, the interconnections that these considerations have in issues that are sometimes more nearer to the lay people than we usually think. So yeah, actually the first example you made about hospitals is quite straightforward, but I wanted to maybe widen a bit the scope also to technologies that we use every day. So yeah, it was just a try to make it more biteable, let's say. So okay, we are running a bit late, but if there are questions from the audience, now it's time to ask them. As I said, you can, as you prefer, type them in the text chat or raise your hand. There is a small icon with a hand on your screen. You can use it to ask us to intervene. No one wants to.
I reiterate the fact that if you might have a question afterward, we are always available. So maybe you might not have a question right now, but after having read the critical analysis, you will have. So please reach out to us if you have questions.
Yeah, as I said, I will share your contacts. So I hope that this will help, like open a conversation on these topics, and maybe be a valuable tool to sharpen also the tools that PanelFit in general is developing to address these issues. So, okay, I will say that we are done. So thank you very much, Alessandro. It was very interesting, very clear. And thank you for your time and for your slot on the calendar, which is, as I can understand, always a sensitive topic.
Thank you very much, Federico, for having me here today. And again, thanks to the audience for participating today and listening to me.
Thank you. Goodbye.
Thank you. Have a nice day, you all. Bye.